Thank you so much, sir, for your valuable words of encouragement. It is now my honor to invite Mr. Sumant Patra, President of the Insolvency Law Academy, to share his perspective and address the participants. Mr. Batra is a globally renowned insolvency lawyer with over 3 decades of experience spanning in policy making, legislative drafting, advisory, and capacity building in insolvency and bankruptcy law. He has worked with leading institutions and served as the youngest and first Asian president of Insol International. Over to you, sir.
Thank you, Ms. Khan, for the introduction. Thank you, Rajiv Gandhi National University and CBLT for inviting me and for inviting Insolvency Law Academy to associate with this conference. I express my deep pleasure for giving us an opportunity and also look forward to collaborating in future, as Manoj mentioned, by way of a more formalized, institutionalized effort. There is a lot that we can do together, and I look forward to the MOU being signed soon after. I would also like to take the opportunity to express the solidarity of Insolvency Law Academy and myself with the people of Punjab who are struggling with a very unprecedented flood situation, a natural calamity after almost 3 decades of that they have experienced something like this, and the devastation that I see on the media and in the newspapers is really very, very disturbing. Professor Dr. Jay Shankar Singh Ji, Vice Chancellor in absentia, Dr. Vats, Dr. Walia, Manoj, Harsh, many of my esteemed colleagues from the insolvency industry, and a very young, attendees who are the future of the legal industry as well as insolvency industry. Manoj has given a very insightful introduction of the IBC and its trajectory over the last 8 to 9 years. And we have read it extensively. It has been debated so widely. It has been reported in the newspapers. All of you know the numbers, the facts, the challenges, the concerns, and at the same point of time, the various points of celebration. I will today speak to you on 3 aspects. First, what I see through my prism as the outcomes of IBC. Second, I will also talk about 2 macro level of challenges, not about, the issues in implementation and things like that. It's rather unfortunate that we have focused overly on those 7, 8 years, and the entire debate has got hijacked about implementation. And I'll explain to you why I say that in a moment, but let me tell you also the third point that I'm going to talk about, which is where now from here, now that the bill is in the parliament and we expect that a lot of issues would get addressed, what next? Let me just mention a few points that I feel are the real impactful outcomes of IBC. I don't want to disregard or brush aside or undermine the outcomes in terms of the numbers. They are very impressive in terms of the cases resolved, money is recovered on account of the IBC cases in NCLT or those that were prevented from going into NCLC as a potential threat. I also don't want to in any manner play down the various other outcomes that we see as measures of success of IBC. They indeed are a contributant and one of the scale at which we might be able to measure the success of a legislation. But they are not really, in my view, the scale at which we can measure IBC's outcomes and success. Because what has happened in the last 7-8 years is that we have looked at IBC from a very, very narrow prism. We just have got so entangled. And I can understand the government, the politicians playing out those numbers, because for them, of course, they need to take credit for those. But those who understand the importance of an insolvency law to an economy, to the financial architecture of a country, to the corporate governance, to the credit market, to policy making, to geopolitics, they would know that the real impact of IBC lies elsewhere. And I can talk about 50 such items. Many of them I've written in my recent book, but in the interest of time, I will talk I'll touch about 5. And I can tell you these are not 5 headline items. There are many others, but I don't want my entire address to get monopolized by the first part of my conversation. To me, one of the biggest success of the IBC is a demonstration, a formidable demonstration of a case that where the government puts its political will and might behind the implementation of any law, that law is bound to be successful and meet its objective. That is what IBC is, in my view, a classic example for case study. Between 1st June and 1st October, 1st June when NCLT was notified, 1st October when IBBI was notified in the year 2016, and then 1st December when the roll out of the process and IBC took place. And first case was filed in December itself. In those 6 months, there was a revolutionary planning of how we should roll out IBC, make it a success in almost all departments. Not just its implementation, but also about awareness from top to bottom down. The length and the breadth. To keep a very close watch on every single development and to prepare a response plan to that. Training of the judges to training of the other stakeholders. And then once the law had been rolled out, and we still saw a degree of reluctance amongst the lenders to pick IBC as a remedy. How Banking Regulation Act was amended, RBI was empowered, and how almost 45 cases, first the dirty dozen and then later on the another 2 dozen plus, were literally pushed into IBC because they held nearly 50% of the NPLs sitting on the books of the Indian banks. And how then, therefore, those 12 cases became the catalyst for testing the IBC on ground and also for laying down a solid foundation in terms of jurisprudence. All this happened, mind you, in the first 2 to 3 years. And I would urge those of you who have a scholarly inclination to carry out a study on this for the benefit of the policymakers, government, and institutions as to how we must implement laws. More, and the silver line that ran through this effort was how it became a collaborative effort. And at some point in time, I'm happy to do a master class on this because I was very hands-on from the day one. And as I said, this is something that needs to be taught to the academics, to the bureaucrats, to the various other stakeholders. That, in my view, is one of the biggest outcomes and learnings. The second, which I touched upon very briefly, is the jurisprudence. Nowhere in the world, not even in the developed countries, which today boast of the most sophisticated insolvency system, had such clear principles of law articulated by the judiciary in the first 3 to 4 years. It has taken 2 decades in many jurisdictions. In India, led by Justice Rohinton Nariman, and then, of course, by many other judges. The top court of the country, the Constitutional Court, gave a very clear example how we must not fail IBC because of its importance to the economy, and how not just in that process we saw various principles of IBC getting clarity and therefore being applied on a day-to-day basis, but also we saw how policy gaps were filled. Jet Airways is again another classic example where we did not have cross-border law, and yet NCLAT came forward and persuaded the insolvency professional in India and the liquidator in Netherlands to sign a protocol for cooperation. That's something which became a global headline and also has been studied and even being spoken about till date as to how the Indian judiciary has demonstrated higher level of maturity. That in itself, in my view, is something which will go down in history. When history will be written, people will not write about how many outcomes happened in 4 years, 3 years. People are going to write, when I write, they write the history of IBC. That's what they're going to write. And you must therefore see my book in your library, recent book, where I devote a full chapter on the first point, the responses. The second, about the jurisprudence. The third, of course, at the micro level, you had the NPLs going down, but the most significant aspect is that how it impacted the credit market. Because there was such high level of NPLs, there was no liquidity in the banking sector. They had lost the courage to lend again at the market. The cost of the borrowing had gone up very high because of the reason that the risk was so high. And what IBC has done is that it has brought fresh energy to the financial sector market, including, of course, besides strengthening the banking sector. The tremendous amount of recapitalization that happened as a part of the whole plan that the government had in the first 4 or 5 years, which is not something that I've written in this book, but my next book that is out in December, which is not on IBC per se, but as a chapter on the policy. I'm writing much more in detail about how IBC was just one part of the building block of the strengthening of the restoring the health of the Indian banking sector and make it more robust. And therefore, IBC played a very important role in that part. And that is from this point of view, the fact that IBC and various other aspects together form the architecture of the economy. And in fact, IBC sits at the heart of it. And therefore, we need to look at it from a very different prism than just sort of citing numbers, which, of course, I say again, are also equally important, although. The next point is that we have demonstrated to the world that we are capable of building world-class institutions right from the scratch and do that well. 4 institutions have been built within the IBC framework from the scratch: the adjudicating authority, the IBBI, information utility, and an entirely new discipline of insolvency professionals. Again, from the scratch, very innovative. IBBI, in fact, is a gift to the world, which the world must see. Again, as to, in particular, in global South, where there are aspirations for becoming a free market economy, but we do not have the supporting infrastructure to build institutions that support and inspire the confidence of the market players in a free market economy. But we have proven that IBBI is one such example that can be followed in many jurisdictions. A bankruptcy court, we may have still a lot that we expect from NCLT, but it has its own constraints, and it has been delivering slow for an entirely different reason. And this is something that I'll touch in my second point as a part of what I call as challenges for future. But I think institutions that we have built is, in my view, one of the areas that we should be proud of and consider as one of the brightest outcomes of IBC. And the fifth, and I think for me, this is again another headline. We have proven to the world that India is capable of not just leading the global South in terms of innovation, in terms of experimenting, in terms of producing world-class laws and institutions, but also show that how these institutions can be successful and very impactful in a short period of time, thus serving and feeding the aspirations of those, not just the aspirations, even the planning of those economies that follow India as an example of where in a short span of 25 years, we have moved from an economy that was down to balance payment crisis on the verge of bankruptcy in 1991, and which had to pledge its gold to IMF, to becoming in less than 3 decades the 4th largest economy, nearly the 4th largest economy, and soon could actually become the 3rd largest economy, which is what is threatening those who have held the position 1 for a very long time. Now the second point, the 2 challenges. There are many challenges that you can cite, and all of us write about it. But it's very unfair to focus on them beyond a point. IBBI, the government has done and continues to do phenomenally well in terms of addressing those challenges. Manoj listed some of those. For example, more than 100 changes in the regulation. I'm not very proud of that. IBBI did what it needed to do, but that's not where the solution lies. And also, of course, we complain, crib, sulk over NCLT delays. Well, you can. Everybody is entitled to, even I do. But then the solution is not just to crib, to complain, and to just say, oh, get more numbers in NCLT, or get NCLT members to work. They work very hard, I must tell you. But then where is the problem? In my view, there are two biggest challenges. I'm focusing on the macro level. I am not focusing the micro level because when you're a nation that is wanting to become a developed country by 2047, you don't focus on micro levels. Micro levels there are many, there are regulators, there are others who focus on that. But leaders, thought leaders, leading practitioners of this country, leading lawyers, leading academics, of course, policymakers, have to think beyond that. And again, I can have about a dozen such areas on which we should think for in order to address the two challenges that I see, or the challenges that I see, number of challenges, but I'll focus on two for the time being today, because I'm going to spend then another 10 minutes or 5-7 minutes on my future issues. I believe the biggest challenge is that some of the institutions that we have created or conceived in the past were never designed for a 21st century India. Many of them were a response to the India of 1980s, 90s, including NCLT. NCLT was conceived in 1999 by Irani Committee as an institution to solve the problems of 1990s under the law as it existed then. Irani Committee had recommended that SICA should be repealed and merged with Companies Act, and a special bankruptcy tribunal should be created under the Companies Act. High Court jurisdiction should be taken away. Even I don't recollect if they had even proposed CLB should be abolished and it should be there. But the fact remains that it was conceived at that point in time to solve a law of 1990s. When Irani Committee was set up, and I was a member of that Irani Committee in the early 2000s, I was able to persuade Dr. Manmohan Singh. I met him together with Premchand Gupta, who was the Corporate Affairs Minister at that time, to expand the scope of Irani Committee, which was to look at the review of the Companies Act, which the Vice Chancellor spoke about. And the Prime Minister agreed that we should include review of the insolvency law as a part of that committee. And then we recommended. The NCLT was, but we were still trying to solve a problem of that time. But nevertheless, the NCLT's constitution was challenged before the Madras High Court. And the famous Madras High Court Bar Association judgment upheld by the Supreme Court held that no, in terms of the tribunalization, you should have retired judges, judiciary manning the tribunals. And of course, in terms of the bureaucrats, they said you can have not additional secretary, but not joint secretary, but up to additional secretary as competent. While when I was at the Irani committee, I had been able to persuade, together with many other people who were in the committee, to have NCLT as a search and selection committee, as where you pick experts from the market to head the institutions and not retired judges or retired bureaucrats. But unfortunately, the Supreme Court, High Court did not agree. And therefore, we had an NCLT which was to be comprising of retired judges and retired bureaucrats. But IBC was nowhere in picture at that time. Even when NCLT's constitutional values were upheld and the government were sort of looking at constituting the NCLT. Then we saw IBC come in and a creation of an adjudicating authority. And the policymakers decided, let's give the power of adjudicating authority to NCLT. I opposed before the Joint Parliamentary Committee. I can't say beyond this because whatever I said, I'm sworn to secrecy there because you appear as a witness. My view is, nobody's written it anywhere, that probably at that point it was felt that If we create a new adjudicating authority and how its member will get appointed, it may get challenged again in the High Court, and we'll see the same fate as of NCLT. For 8 years, we will be caught in the legal challenge. IBC will not get implemented. And since NCLT's constitutional virus has just been upheld by the Supreme Court with some changes by the Parliament, let's just use NCLT. That is how NCLT came to be accepted as a choice for becoming a adjudicating authority. It was not the first choice. Should not have been. But now the time has come for us to take that leap and have a brand new adjudicating authority of its own under the IBC, where the members are selected not by selection committee, but a search committee, where the committee invites experts from the market to head the NCLT. That is when you will find real problems at the NCLT getting solved. I won't spend too much time on that. I'll move to the second topic because I have only 7 minutes left. The second is one of the biggest concerns that I have is that all those who are benefiting from the insolvency law over the last 9 years, by becoming leading lawyers, leading insolvency professionals, and bankers, they have to invest heavily in building the insolvency industry of India, which is world class, meets global standards, and rise above their own individual gains and aspirations. Our aspirations will be met by the insolvency industry if we are able to build an insolvency industry which is world class. We have to support every initiative and move wholeheartedly, including by financial resources, which is how Singapore built its insolvency industry in a short span of 7-8 years. When I was the executive committee member of Insol International, I met a few people, very leading professionals in Singapore, and persuaded them to set up IPAS, Insolvency Practitioners Association of Singapore. Justice Kannan Ramesh, who was then a lawyer, Patrick Ang, unfortunately deceased very recently, Ashok Kumar, Black Oak, who recently merged his practice with Bird and Bird. Then he was with Allen and Gladhill. Surjit Singh, he was the president. He was the he was the regulator of insolvency department, and some other people as well. We got together and created IPAS, Insolvency Practitioners Association of Singapore, about 8 to 10 years ago, maybe 14 years ago. Look where it is now, amongst the best in the world. And they're building Singapore as the global destination for restructuring. Leading examples by setting up judicial network. And God knows what else. They are on a mission. And it's because every person in that country who's associated with insolvency is working with that mission. While unfortunately in our country, we tend to work for ourselves, pulling ourselves in the energies in different direction. And it's not a complaint, and it's not a criticism. I am only saying this so that we realize it and make it very visible as an effort. I'll pause here, but this is something which I'm going to continue to talk about in future and other platforms. I'm going to shift to my third topic. What next? I believe that there are still many agendas unfulfilled, and also many that have popped up globally, and some those that are very dear to my heart, and also I'm sure to many others, but certainly I know to some people in the Prime Minister's office on the economic side who believe that we need to work on those aspects, and I'm going to touch upon those a few. First of all, we must realize that corporate insolvency is not the end of the world. It is not the entire insolvency system. We don't have individual insolvency fully implemented. So that is one part, which at least thankfully is part of the IBC, but not even worth the paper it is written on, I'm sorry to say. But in my view, we need to expand the expanse of the insolvency to take it to the various other aspects. The low-hanging fruit, of course, is the banking sector. Worldwide, most sophisticated economies have a separate law, insolvency law for financial institutions. We attempted it in 2017. You know that the bill had to be withdrawn in 2018. And then, we saw crisis in DHFL, IFS, some of the other SREI and others. And when that was becoming a bit alarming, the government decided to amend the IBC and include FISP as a part of that as a stopgap arrangement. But I hope and wish that it doesn't continue to sit there perpetually. We need a very different, sophisticated approach to bank insolvency, and that is something which we should. And hope it will happen because the unit right, which over the last 10 years was working on a framework, a kind of a model guidelines for insolvency of small and medium enterprise banks, has just come out with its model law, model guidelines, which we are expecting will be approved by the General Assembly very soon. RBI was a part of the working group at the unit right. I had the privilege of being invited ILA had the privilege of being invited as an observer. And I can tell you that if that is approved by the General Assembly, hopefully in next year, we will have some action happening on that. Second is climate change. You see this impact, one in the direct cost of flooding, which our farmers, our people of Punjab are facing. And the second, indirect cost of all of us having had to cancel our plans and move to online. This is not just financial cost. This is the cost of how it might impact various plans at short notices. There are many others. I don't want to talk too much about that because I've already written a detailed paper at ILA on this, together with Professor Raghav Pandey, which we have spoken about at the global forums. World Bank, INSOL International III constituted a working group on this of 12 global experts. I had the privilege of being a member of that. That paper will hopefully come out, but given the geopolitical situation at the moment, I'm sure that will come out as a very cautious one. And we may not really see a wholehearted, full-blooded drive on this, but nothing stops India as an example for not just global South and global North to take a major initiative by making some policy tweaks to accommodate the impact of climate change on businesses, economy at large, and the businesses in turn. And I think, again, I am going to request you, the young scholars, to write more and more about this topic, because the policymakers act only when there is a demand from the market and there is enough literature as well. So please do write, not just the young scholars, but even the academics who are attending this. Please do write more on climate change. The third, in my view, is the mediation. Again, I won't talk too much about that. You've seen yesterday, Chandrababu Naidu, the Chief Minister, also Andhra Pradesh, spoke about it, made headlines on the newspapers. We saw arbitration week in Singapore last week. There is something happening in India this week. Again, in Bombay next week, there is a huge amount of impetus drive to bring in alternate dispute resolution as a mechanism to reduce the burdens of the courts, to make it cost effective, to satisfy the litigants that their justice dispensation system is more accessible, less expensive, speedy. And mediation is something which is of the top priority as well. We were hoping that some enabling provision will come in the IBC bill, but I'm not disappointed because the fact remains that the Mediation Act itself although notified, hasn't really been implemented as yet. We haven't really seen even the mediation council being set up. I've had some discussion with the law minister on that as well, and hopefully that soon will be rolled out. And once that is rolled out, we might just be able to get a provision in the mediation bill, at least an enabling provision, so that we can have that rolled out as well, because everybody is very keen. The fourth is, in my view, one of the most important issues. I think, given the geopolitical developments and what you saw as the GST tweaks announced in the last 2 days, and the fact that our small medium enterprise is still struggling, especially the small enterprise, which contribute 33% to the Indian GDP, largest employment providers, largest foreign exchange earners, the backbone of our economy, thus the bottom of the Indian pyramid of Indian economy. 94% around of the medium and small enterprises, some medium as well maybe, are proprietorships. Millions of enterprises. About 2% are partnerships with, and I'm going to wrap up in next 2 minutes. I know that I overrun my time by 3 minutes. Are partnerships with unlimited liability. We need a law for them. PPIRP, individual insolvency law, as it sits on the IBC, is not going to work. We need a major disruption, created disruption, even destruction. And for ILA over the next 2 years, other than the 3 topics that I've spoken of, and in the interest of time, I'll skip the 5th one. My focus, individual also, will be on small enterprise that run their businesses in an unorganized way. We have constituted a global roundtable on this of experts. We are producing a white paper for the government in the next 1.5 to 2 years, which will be like a deep study of the market, Indian market, global north, global south, a comprehensive legislative brief to address the problems of small enterprise through insolvency framework. And we're doing a kind of hoping to do one kind of a pilot project of that already with one of the state governments. I can't mention which one, which has liked the idea in my book on that and is working on that in some way. Obviously customize it, because my idea in the book is very broad, but how do you sort of convert it into a toolkit is that state government is hoping that it can experiment with over the next 1 year. With this, I just make one closing comment, and I apologize for overrunning my time, that please, while many of you should focus on the micro issues as well, it's important. But please look at also the macro visionary issues. Ideate in your papers. You are the people who are going to be future leaders in not 20 years, but in 10 years. You are the ones who are going to be out there. Either some of you may join the parliament, the legislature, judiciary, executive, academics, insolvency industry, profession, researchers. Please don't look at insolvency from a narrow prism, from a narrow view. You will find that it is a horizon which is very difficult to capture in a lifetime, which is what I am saying. Having spent 35 years in this area, I still feel that there is so much that I could have done, I still can do. And I hope this is a baton that gets passed on to many of you who continue to do passionately what we do at ILA. Thank you so much once again for inviting me, and I look forward to interfacing with you in future as well. I'll be around for some time, but I may not be able to stay back for the panel as such because of some other commitments. But I wish my colleagues, many of you I know very well, and I wish you all the best with the panel. I'll stay for some time, but I wish you all the best. Thank you so much again.
Our heartfelt thank you to you, sir, for such valuable insights, gracious words, and for making this conference even more special for all of us. We will surely take forward the perspectives you have provided for deeper discussion and analysis. Now, to conclude the inaugural ceremony, I request Dr. Manoj Sharma to kindly deliver the vote of thanks and formally close the inaugural session. Over to you, sir.
Thank you, Muskan. Thank you so much. I have been given this task of proposing vote of thanks, and at the outset, I take this opportunity, first of all, to congratulate the students who have worked relentlessly during the last 3.5 or 4 months to make this conference happen. My thanks are due to Professor Dr. Jaishankar Singh, the Vice Chancellor, Rajiv Gandhi National University of Law, for his unflinching support, his motivation, encouragement, and guidance, not only in organization of this conference, but also in organizing many other conferences which we have been organizing from time to time. He has been a continual source of inspiration and has been persistently encouraging us to go ahead with these activities, despite the fact that we have been troubling him again and again. Today also he was traveling, he had a convocation address also, but we requested him that you have to join and he obliged. So we are indebted to you, sir. Of course, thanks are also due to our Dean Academic Affairs, Professor Dr. Naresh Vats, the Dean Academics at RGNUL, and the Finance Officer. For his continual support, his encouragement, his motivation, we are thankful to you, sir, for your words of wisdom and also for highlighting the importance of these academic events for the students and also for the industry. He has very kindly guided us and advised us at all levels. So we are beholden to you, sir, for your help, for your support, for your motivation and guidance. Thank you, sir. I'm also grateful to Mr. Sumant Batra, President, Insolvency Law Academy, for his inaugural address outlining the outstanding achievements of insolvency and bankruptcy regime set forth by the Code of 2016. Not only for this, but also for always lending a helping hand whenever we have approached him, for organizing various events. And also, sir, I'm looking forward that we meet soon in the offline mode and we have that MOU which somehow or the other could not be signed, institutionalized so far. And we are thankful to you, sir, for summing up the solutions, including the appointment of a new adjudicatory authority, and also for bringing in the all-important topic of climate change. I must also put in record my deep appreciation to the panelists who are going to join in a short while. Professor Jason Harris, Professor of Corporate Affairs, and Director Ross Pearson Center for Commercial, Corporate, and Taxation Law at the University Law School, Sydney. Mr. Siddhant Kant, Equity Partner at Shardul Ramachan Mangaldas. Mr. Akash Chandra Johri, Co-Lead, Corporate Law and Financial Regulation Team of Vidhi Center for Legal Policy. Mr. Ankit Goyal, Chartered Accountant and Insolvency Professional, and founder and partner at AAA Insolvency Professionals, and Ms. Pooja Bahari, the Insolvency Professional, also for joining this conference. I'm beholden to National E-Governance Services Limited for the financial support and also for encouraging us to organize this event. I'm grateful to our collaborators, ILA, IBC Laws, Live Law, Shardul Amachan Mangaldas, Mentbrew, and National E-Governance Services Limited. I'm also indebted to the Registrar of the University, Dr. Uneet Kaur Walia, for her continued support. Unfortunately, due to her unavoidable issues, she could not join today. I thank her in absentia for her support. I'm grateful to my colleagues, Dr. Bhinpreet Kaur and Dr. Ankit Srivastava, the co-coordinators of this event. I'm also grateful to my faculty colleagues, especially Professor Dr. Sharanjit, Dr. Gurmanpreet, Dr. Sangeeta Tak, Dr. Shivasti Sharda, and Dr. Susanna for joining this conference. I would be failing in my duty if I do not acknowledge the strenuous work put in by all non-teaching and sports staff who have been working for the last 2-3 months to make this conference happen. Words cannot adequately express my gratitude towards the untiring efforts for all the students who have been rigorously preparing for this international conference and who have sacrificed their food and rest hours for making this conference happen. Special thanks are due to Mr. Harsh Bansal and Mr. Akshat, the conveners of the Insolvency and Bankruptcy Law Division of the Center for Business Laws and Taxation. I'm also grateful to the entire CBLT team who have, in a short span of little over than 3 years, have organized 8 conferences, 10 certificate courses, the article writing competitions, the blog writing, the monthly newsletters, the case digest on IBC, so on and so forth. I salute the entire team for their untiring efforts. Of course, no function can succeed without the active support and enthusiasm of the students. As I said, as we all understand that due to the devastating floods in the state of Punjab and the closure of all education institutions, the students have put their foot down that we will make this conference happen, if not in offline mode, but in online mode. So we are thankful to our student volunteers and the entire team, and we are grateful to all of them. At this juncture, I pray to the Almighty for the health and well being of everyone, and I pray for the well being of all people who are affected by this devastating flood. And I ensure them that this university and the entire student community is standing shoulder to shoulder with all those who are affected by the floods. So I thank everyone who have joined today, despite all odds. Thank you so much. Thank you, everyone.
Thank you so much, sir. On behalf of the organizers, we thank each one of you for your presence, enthusiasm, and support in making this conference a grand success. I now kindly request everyone to stay connected as the panel discussion is scheduled to start in the next 10 minutes and will continue on the same link. Good morning, sir. We'll begin with the
Good
panel
morning.
discussion in the next 5 minutes.
Okay, no problems.
Welcome, Professor Jason Harris. Thank you for joining. Thank you so
Thank
much.
you for inviting me. I'm looking forward to it.
Thank you. Thank you so much for joining on behalf of the university and my center, the Center for Business Law and Taxation. I welcome you, sir. Thank you.
I used to work in a Centre for Business Law and Taxation at University of New South Wales many years ago.
So, I'm also heading this center at Rajiv Gandhi.
Wonderful.
Great to have you, sir. Thank you.
So this is a 2-day conference, is that right?
Yes, sir. It is a 2-day conference. So today we have the inaugural session, which ended 10 minutes back. And now this panel discussion. Thereafter, we'll have in 2 days 8 sessions, technical sessions, where we'll have 43 paper presentations on varied aspects
wow.
of insolvency and bankruptcy.
Wow, that's wonderful.
Yes, sir. Thank you so much, sir. Welcome, Siddhanji.
Thank you, sir. Good morning. Good morning, everyone.
Thank you for joining.
Always a pleasure.
Thank you. Thank you. Welcome, Madam Pooja. I can see you. Sorry, I couldn't welcome you earlier. Thank you so much for joining. Thank you.
It's my pleasure, sir. It's my pleasure to be here. Look forward to the deliberations.
Welcome, Ankit ji. Welcome again.
Thank you, Manoj. Thank you so much.
Thank you, sir. Thank you. Akash ji, thank you for joining. Mr. Akash ji.
Yes, sir. Thank you. Thank you so much
for
for
joining.
the
Thank you.
invite,
So I think the panel is complete now.
Yeah.
Yes, Muskan, can we start?
Yes, sir.
Please.
So, with the inaugural session successfully concluded, we now move on to the panel discussion on the very pertinent topic Group Insolvency Framework in India Issues, Developments, and Reforms. This panel brings together leading experts and practitioners who will share their diverse perspectives on the challenges and opportunities in involving India's Group Insolvency Framework. We welcome all our panelists and look forward to an engaging and insightful discussion ahead. I now hand over the session to Mr. Ankit Goyal, who will be moderating this panel discussion. Thank you. Over to you, sir.
Thank you so much, Muskan. Thank you so much for introducing the panel to all the delegates of this conference. And it's indeed a pleasure to be here at this platform I do join others when I say that it's a difficult time for many areas in Punjab, and we really wanted to be there physically. All of us were wanting to do that, but unfortunately, we are having to do the same virtually. I will, of course, would want to, briefly ask the panelists to give a brief about, themselves, and also share a little bit about their experience in insolvency when they first speak. I will start with maybe asking Siddhant, who is a partner at Shardul Amarchand Mangaldas, to share his views with respect to how the law in India has evolved with respect to the nitty-gritties of separate legal entity, and how that is a challenge to group insolvency, or how should these two interact. I understand that Siddhant has also been key to many of the dirty dozens that came into insolvency, and he's seen some large groups entering into the insolvency process, and we'll be able to share the challenges and the advantages of having standalone insolvencies that have happened so far, and some group entities or group insolvencies that have happened in exceptional circumstances.
Thank you, Ankit. Hi, everyone. So just as an introduction, I've been in the insolvency practice for the last 8 years, effectively since 2016-17, effectively since the time IBC came about. So I have grown into this practice area along with the law altogether. So coming to the whole topic here, see, the very basic principle of companies law in across the globe talks about the concept of a separate legal entity, whereby a company in itself is separate from all its shareholders, is independent of its shareholders, and it's a distinct and a separate entity altogether. And this is something which forms the very basic of Companies Act, right? And this started with the whole, this concept was first recognized in the case of Solomon versus Solomon, which all of us would have at some point or the other during our law school or legal practice gone through this case altogether. And this has in fact been adopted in India altogether in various and numerous cases, starting with maybe I wouldn't say starting, but one of the landmark earlier cases was Bacha Guzdar, which was a constitutional bench judgment which clearly said that assets of a company and assets the shareholders have no rights over the assets of a company. And going ahead, there was Vodafone, and in the recent past, there was Needle Industries, there was Vodafone, and so on and so forth. But along with the concept of also been an equally important legal principle of piercing the corporate wheel. Now, piercing the corporate wheel, while used scarce. Sorry, there was some network issue. So, but piercing the corporate wheel don't use scarcely and not as often, but is something which is definitely something which exists in the jurisprudence of our country and globally, and is generally pierced. The wheel or the corporate entities pierced in the cases of fraud, tax evasion, or in case of evasion of seeking to evade some kind of a compliance under any kind of law. So those were the situations wherein this corporate entity, separate corporate entity, was pierced through. But this, so while this concept has existed for now close to 150 years of a separate legal entity, but with the modern structures which have come into being today, right, there are so many interlinkages between companies effectively. So you see there are companies within having a common ownership, which are basically synergizing in a fashion where they complement each other. There can be some kind of a horizontal linkages which they have. There might be vertical linkages which they have. And this is being done to ensure that there are effectively economies of scale. So one company will, for instance, for example, if I am a auto part manufacturer, I will have one company of mine which is dealing with ball bearings effectively for those auto parts. Another group company dealing with another set of parts which will help us formulate the final and assemble the final auto parts. Now, this is something which happening a lot in the country. For another example could be real estate companies, wherein company A is the landholder, company B is the developer, and company C is the person who's marketing and selling it. So all these are together. So, and in such a scenario, when bank lending happens, the bank lending happens from the perspective of the overall assets of the group, and not from an individual company's assets. So therefore, there will be cross security at the end of the day, and the bank looks at the overall picture of a group to figure out what are the common assets, and accordingly what kind of monies can be advanced to them, keeping in mind what security they're getting. So these complex issues is why the whole concept of group insolvency is being brought into not only in India and in fact globally itself. So if we look at it on a global front also, the UNCITRAL model on insolvency laws came in the 1990s. Whereas the whole discussion regarding group insolvency is very recent. For example, the European Union only came out with their group insolvency law in 2015. So you can see that because of the complexities, it was never in fact originally envisioned when the model law was brought about. And that is where today's discussion is going towards. And here, then we talk about group insolvency per se. There are two types of group insolvencies. One is a substantial group insolvency, which talks about combining the assets and the liabilities of all group companies together into one common pool and then resolving it. Whereas there is also procedural group insolvency, whereby only procedurally the independent processes will be run for each of the companies, but procedurally they will be coordinated. Now, when we see how this has developed in our country altogether, subsequent to the coming in of the IBC, one of the most stark examples we have today is of the Videocon group, right? Wherein Videocon group, 13 entities were brought in together to have a joint insolvency process for them. Now, here, if we see that in the case of Videocon, it was a substantive consolidation, and whereby all lenders were brought together and it was substantially undertaken. Whereas what we are seeing right now, by virtue of the discussions happening vis-a-vis the committees formulated, as well as vis-a-vis the amendments which are being sought to be made, are more in the nature of procedural coordination vis-a-vis group insolvency. And this is also a difference which we can see globally. For example, EU is someone who talks about only procedural group insolvency, whereby there has to be procedural coordination. On the other hand, laws in the US, and if Professor Harris will correct me if I'm wrong, but even in Australia, it's more of a substantive coordination when it comes about into group insolvency. So this is effectively slightly different. So when we talk about substantive insolvency, that is something which goes slightly against the whole idea of a separate legal entity. Whereas when we talk about procedural group insolvency, that keeps the independent nature of each entity intact, whereas the processes will go independently. However, they will be coordinated from the perspective of to ensure value maximization.
Great. So I think thank you so much for sharing your thoughts. Just one follow-up question before we proceed or we move to Pooja ji and understand her thoughts. What was the chief reason that you found in large group companies that they keep the core operations segregated into different companies? What is the objective of this kind of a corporate structure where they keep the main operations of the company in separate entities which are all interlinked with each other?
Right. So see, one of the primary reasons for this, and if you look at it from a company's perspective, is ensuring that there are focus groups within the company which are focusing on A, B, and C, right? And it is better management for the company altogether. If you have each company being led by a different set of managers altogether, it helps in breaking it down and ensuring what would I say, expertise in that particular region, right? Rather than everything coming under the same umbrella. Equally, what also have such a structuring is undertaken is from the perspective of maybe tax efficiency, right? Because there may be certain benefits from the tax perspective which may be given to a certain set of industry which is being run. But if you bring it all under the same umbrella, then it may not be those benefits may not be available. So there are multiple reasons which we can think of, but some of them could be expertise, tax efficiency, and so on and so forth.
Are the companies also able to increase the level of debt when they have a structure where their main operations are segregated into multiple entities? Is the level of debt increases or capacity of taking debt increases over multiple entities?
So Ankit, it may not be true, very honestly, because of the fact that at the end of the day, when the creditors are are disbursing the debt, they are looking at the overall asset picture of the company, right? So so strictly speaking, dividing those assets into multiple companies may not result in further debt being granted to them, because they are looking at what security they're getting, and the debt is being granted basis the same.
Right. So a recent example where we were doing the valuation of the shares of a company, we were given this assignment to value the shares of the company by a bank, and we were kind of choosing as to whether to consider a debt or not. And because that company had not given a guarantee on behalf of its associate company's debt, and it had only pledged its shares for that kind of debt, the value turned out to be very different. So this was one of the reasons, because a slight legal change in how the structure of the debt was made resulted into big change in the value of those shares for the purpose that we were working on that. So I think I wanted to give that example to everyone as an example of how a slight legal change can bring out a very large difference in the value of a company. I believe I will now move to Pooja ji. Pooja ji, we of course I think was one of the pioneers who started insolvency and who was one of the first few who started practicing in insolvency. And before that, also, I know that Pooja ji has been in the space of helping banks reducing their NPA since a long time. Pooja ji, can you give everyone a brief introduction about group insolvency, what its journey has been in India, and where are we now, and what are we expecting in the amendment bill as part of the group insolvency framework that is being proposed there?
Definitely. Good afternoon to everyone. So, of course, very kind introduction. And for me, that I have been the third woman insolvency professional in the country. So, doing a lot of work in this field, helping to make a lot of jurisprudence in the right direction. So I think we have a very relevant topic today, primarily where we are going to be, discussing the CBIR C2 recommendations, and what is the India stance on the UNISTRAL's model law. So I'll just give a brief introduction, primarily that we, with the insolvency field, when the CBIR sees that is the cross-border insolvency rules committee's recommendations came. So they primarily were there for strengthening the India's insolvency code, they wanted to incorporate certain aspects of the UNISTRAL's model on the cross-border insolvency, focusing majorly on cooperation, basically cooperation between the courts and the insolvency professionals, and how to have a direct access for the foreign representatives, and how to resolve cross-border and group insolvency issues. That is something which had been the key recommendations. I think everyone would know that the CBIRC2s, they were the committee was appointed by the Ministry of Corporate Affairs, and they had given a report in December 21. So what brought about was primarily phase introduction. They wanted initially was most important was that they wanted a domestic only group insolvency framework initially, and to defer a broader adoption. They wanted that initially we should see the implementation side of a single entity cross-border insolvency structure, how it worked out. So basically, the one of the most important regulations, what came out from that report was that they did not want to immediately adopt the UNISTRAL's model law, with reference to the enterprise group insolvency. So they advised that it should not be adopted at present. So this was of 2021, because it could be considered later. But once they thought that India should first gain the experience, the practical experience with cross-border insolvency laws. So, and it was thought out that we'd have a voluntary and a flexible framework during the group insolvency regime under the IBC. So it wanted to, it should be voluntary, it should be flexible, and there a lot of procedural coordination issues were addressed in it. That there could be joint filings for group member insolvencies, how to transfer the proceedings. There should be a single bench. There could be a common insolvency professional. Of course, the committee of creditors also, they said that they could opt into a group coordination proceedings, having a group coordinator, etc. So it was a very careful, a very phased, India-centric approach, which was there in that report, which which would primarily emphasize that there should be coordination, there should be flexibility, and but yes, one very, again, like I said, a very important aspect of this was that there was a domestic first approach. They said that we should have a voluntary, flexible group insolvency regime initially, so that, and first single entity cross-border insolvency law should be there. So they said the cross-border should not be for group insolvencies initially. And it did have a very limited scope, with this recommendation. They said that it would only apply to those companies which are already in an insolvency or in a liquidation process. So these were the, recommendations at that particular point of time. One important aspect with reference to India, again, was that India had not formally adopted the model law for the enterprise group insolvency. But then again, there has been a lot of emerging judicial decisions which reflect the same model law principles. The model law principles which were there, whether it was in Jet Airways, in Videocon, has been substantial coordination. Extremely important right now from us to see when the IBC, we are talking about the future. This is a very important aspect, that the amendments which are going to come are actually encompassing the proposed amendments. They have the potential again to have the same, towards the country's approach towards the group insolvency, towards cross-border. And India stands on adopting a very international framework, like the UNISTRAL model law is now something which is reflected. So in these proposed amendments, a lot of key changes have been again now sought. This is what we initially talked about, is what was the CBIRC's use recommendation. So now in response to those recommendations of 2021, now the proposed amendments which have been, again, it is on the same lines, that we would have a phased adoption for the group insolvency, a step-by-step approach, first to focus on domestic groups. Again, the same principles, joint applications, consolidated proceedings. Again, what is given in the proposed amendments is by far a lot of what has been given in those recommendations of CBIRC2s, which had not till now been adopted. So, whether it is having an NCLT of a single resolution RP, single NCLT, again, the group committee of creditors, common RP. So all those are, recommendations which we saw earlier in 2021. And now we can actually see them come into, with the proposed amendments. Hopefully, of course, the details is something which will come a little later. So, but the cross-border insolvency, international framework, we had the sections. We had the sections 234, 235, which were already there. But now, how these sections will deal with reciprocal enforcement of foreign insolvency judgments, how there would be recognition and enforcement, how the UNISTRAL model law will now be, it's a further alignment with the UNISTRAL principles, is something which we are seeing in the proposed amendments which will be coming in. So it's a very, very important time for all of us with reference to cross-border and group insolvency. So this is my initial brief. I'm sure I have, very senior panelists who will give their view on the same.
Thank you so much, Poojaji, for that quick brief. And to add to what you said, I think I can maybe add to some timelines that we have been seeing on all these events in India. So 2019 is when this model law was introduced, or rather completed by at UNICITRAL level. And 2019 itself, we in August 2019, NCLT gave that Videocon judgment, which is again something which is a pioneering judgment for group insolvency in India, and which has been used in multiple cases since then, which kind of set the bar of common control, common shareholding, and how the operational interrelationship has to happen. And then there also, Videocon group actually was 15 companies, but they grouped only 13 companies because those were the entities which were interlinked. Also to mention, they only interlink those companies which were insolvent and not other companies which were solvent. So all the ideas that we are carrying forward today, I think, are also coming from that jurisprudence that was created. In 2021 is when this committee, of course, BLIRC committee, which was talking about cross-border insolvency committee, which we're talking about, this report came in. So we have this context that is coming in based on which we are working today, coming out in 2021 itself. So I think with respect to moving towards group insolvency framework or using jurisprudence to create this framework in India, we have been ahead of our time, considering that our insolvency law is very young as compared to others in the country. I will now come to Akash, and Akash Chandra Johari. He is he's at Vidhi Center of Legal Policy. For those of you who are not aware, Vidhi Center of Legal Policy has a deep role in almost every statute that comes out of the parliament. They are advisors, and this center is very, very important with respect to policy drafting for the government. I believe, Akash, you can share more insights on about this committee report and about how we and why we changed, or why we did not formally adopt this model law, and what are the major changes or major differences that we have kept here between what we have done finally, or what is recommended in this policy finally, and what was actually the model law in UNCITRAL.
Yeah. Am I audible, Ankit?
Very much, Akash.
So thank you so much, Ankit, for the introduction. So as a background, I am a co-lead of corporate law and financial regulation team at Vidhi Center for Legal Policy, mainly doing policy and research work related to insolvency law and financial sector, regulators, regulatory framework of such regulators. So I just wanted to share some personal views that I have on how the CBIRC report actually came about, and also what are the basically challenges that were highlighted and by the CBIRC report in relation to adoption of the model law of enterprise. So before the CBIRC report actually came, there was another working group committee report which actually was there. And when the working group committee report was actually coming out, that was parallel to the time when model law was actually coming out with the enterprise group. So when CBIRC2 was actually working, they had an opportunity to review both aspects. Firstly, the fact that what was happening in India, because in India, as all the esteemed panelists have already discussed, there was a huge jurisprudence that was evolving with respect to dealing with group companies. And there were certain elements of substantive consolidation, as it has been discussed earlier, was also being traced out in the Indian jurisprudence. And again, just reiterating for the audience, basic difference between the substantive and procedural is that on the substantive side, basically, you see group as a single entity. You will basically combine all the assets and liabilities of the group and try to consider them as part of one entire process. On the other hand, as compared to in the procedural coordination, generally the discussion is that you ensure that there is a voluntary option for all the participating separate legal entities and their creditors to voluntarily participate and come up with a coordination process rather than substantially aligning all the assets together. So as I'm sure later on the panelists will be discussing about the substantive consolidation aspect, but from a committee reports perspective, both the committee reports, the working group earlier and also the CBIRC later, they mainly focus on the aspect of procedural coordination. And from a procedural coordination perspective, something which was very interesting to see the way the CBIRC report, because Pooja ji has already given a background of the report, I'll dwell a little bit more into detail about what committee actually recommended, the framework that was actually envisaged by them. So one of the core discussions in any jurisdiction, whenever the question comes of group insolvency, is to define the group. Like, because as we were discussing earlier, when we have a body corporate structure, like an LLP or a company, then it is very clear that it's a separate legal entity. This jurisprudence is generally evolved into Like it's something that has been continued into the common law jurisdictions, and in India also it's a very clearly established thing. But one of the most litigious point a lot of time comes up with the fact that what exactly do you mean by a group? There is a single economic entity theory. There is also a group understanding under the arbitration law. So the committee basically defined the group by saying that they are basically two or more interconnected companies, which are interconnected by virtue of a control of significant ownership. And it also includes holding and associate companies. And they also have a definition of control, which basically means that there should be some level of indirect and direct control that you are exercising over the management. And significant ownership, basically, they said it should be more than 26% of voting rights. Now, this was the broad understanding of the group that premised the entire framework that the committee discussed. Committee mainly talk about two aspects. Like if you see the committee report, there are two aspects which can clearly come out. One of the fact is that one other aspect with respect to group coordination proceedings. So these are the similar set of proceedings, and I'll also explain how, in a bit, it's also similar to the planning proceedings, which are also there under the model law of enterprise group. And then the second aspect is to facilitate coordination and communication. So there are two sets of recommendations that the committee broadly gave. One was the fact that let's have a common adjudicating authority for group companies. So if you want to go for a joint application, so right now, if you see the way our section 7, 10, section 7, 9, 10 are structured, they basically require you to file a CIRP application only for a particular entity. They don't give you an opportunity to file it for multiple groups in total. There are certain jurisprudential aspects. What I'm understanding is that in the real estate sector, there are cases where people are filing joint applications with respect to multiple entities, which are involving into the same project. But that's a separate set of sectoral and real estate jurisprudence that is actually evolving. Otherwise, the way the provisions are structured right now, they only require a one-to-one filing by a set of creditors against a company. So one of the recommendations of the committee was that why don't we have a provision for joint coordination? And in fact, if you see, these things can also be traced out, because initially when the IBC was introduced, under section 60, they have a requirement where they can be a common adjudicating authority for guarantors and the companies. So while they might not be actually envisaging a group structure, but coordination through a common bench actually helps, because if the same adjudicating authority or NCLT is actually looking on a matter, it will be easier for them to trace out and flesh out the differences that can happen on the procedural hassles issues. The second mandatory requirement that the committee actually said that there should be an obligation for the RPs and the COC, the RPs and the liquidators basically to coordinate. And as Poojaji also mentioned in our discussion, that the main idea was that the entire group framework that the committee recommended will only come into picture for insolvent companies. So if there's a solvent aspect of a group, the group framework that CBIRC proposed will not actually include them also in the group insolvency proceedings. So only when there is an aspect of insolvency and the proceedings are started, and the framework can actually be initiated. Now I'll just give a small introduction, like background of what do the committee envisage of a group coordination proceeding. So what they basically discussed was this entire, group coordination proceedings will have three major aspects. One is the idea of a group coordinator. So for example, if one or two companies of the COC would want to initiate a group coordination proceeding, they can reach to the NCLT. They can initiate this process, and different COCs of the company can voluntarily, by virtue of there's a voting threshold of, to my understanding, 66%, they can basically become a part of this group coordination proceedings. There'll also be a group coordinator who will be an IP who will be appointed. And ultimately, the idea of this coordination proceeding is to come up with a group strategy. So some of the elements of a group strategies can be that they can, for example, come up with the idea that there will be a common information memorandum for the companies. Or for example, they can be a common way in which they'll be reaching out to the resolution applicant. So the synchronization on that aspect. One caveat that the committee also actually mentioned was the fact that the power to have a common, like for example, if the resolution plan has to be approved, that is not a power that can be delegated and decided by this group COC. That ultimately remains with the respective COCs of the group companies which are participating in the entire process. So once that is done, then the entire idea of the coordination proceeding is to come up with a group strategy. And within the group strategy, and just a caveat, at all stages, the companies can come and participate in the process. And so it's completely a voluntary and a flexible process. And once that group coordination, the group strategy is actually formed, ultimately it will be implemented and it will be binding on the people who have basically agreed to it. So this was broadly the group coordination structure that the committee recommended. And as it has already been discussed, that the committee basically said that while they were considering the model law on enterprise group, their understanding was that today, because there are three aspects. One is the fact that the entire group jurisprudence, as some of the panelists were saying, is of a recent discussion. So they wanted some level of stability to basically adopt model law. The second aspect was they also saw that in India, that jurisprudence and their technical expertise will develop over the period of time. So what I understand is that their understanding was basically, let's go with the domestic group insolvency first, and with time, once those expertise is developed, then there can be a expansion in future. So that's one of the broad things that were there. The another interesting thing is that the way the model law and enterprise group is actually structured. It basically also have a requirement wherein there can be a concept of a planning proceedings, which can be initiated at the behest of a company, which is integral to the group. And once those planning proceedings are basically completed, there is a strategy which is formed. Then you can go for a recognition of that following proceedings to at other places. So ultimately, still the enterprise group model which is there, it mainly focus on the idea that it has to be a cross-border group insolvency framework. So to my understanding, that was basically the limitation. And to date also right now in UK, to my understanding in 2023, they had a discussion where they were planning to adopt the group insolvency model, but still it has not been adopted. Because for example, similar to the cross-border insolvency law, the reason why it's successful is because there is a synchronization that has happened to a lot of countries that has actually adopted it. But when you compare the same with group insolvency law, because group structures as a concept is something that has been evolving in different jurisdictions, wherein every jurisdiction is having a different approach to how they define group, what they do mean by. So that coordination will be a time-taking exercise. So probably by the time there's a more of a global recognition to the idea of model of enterprise group, India will also be moving towards this journey because they will have a more established framework of insolvency law, and then I think they'll be a best position to unite in future. Yeah. So these were some of my initial thoughts.
So thank you so much, Akash. And to summarize what you say and maybe add a few bits from my part, I understand that the framework that is now before us or that is recommended by the committee, which is mostly adopted, one does not really talk about or mandate, I would say, or make it compulsory that you go for substantive consolidation. It says that substantive consolidation is something which is already evolving through jurisprudence, and the committee recommended that let it evolve through jurisprudence, that what are the scenarios when substantive consolidation should happen. To give the participants more idea, substantive consolidation would mean that irrespective of the balance or imbalance between assets and liabilities in each of the group entities, between the assets and the creditors, substantive consolidation would mean that I'm making a pool of assets, I'm making a pool of liabilities, and deciding who gets what. So it has the advantage that yes, it makes it easier to delete cross entity level claims. So in case, to give an example, a bank has financed A and also then maybe pledged the shares of B, which is its holding company of A. So in that process, the bank has a legal claim on both the entities. So when committee of creditors is set up, depending on the actual documents, they might have a claim against both these companies, which will be again the full claim. So that results into duplicity of the claims. And therefore, then when you kind of allocate different assets or allocate various monies being payable to the creditors as part of the resolution plan, the difficulty is that some people are claiming it twice, some people are claiming it thrice, some are claiming it 4 times, and you want to pay them only once because that is the basic level of their claim. So that's one that I think is a result of the committee's idea. That's why we're talking about the procedural coordination. And as I understand from my reading of the committee's recommendations and my reading of the draft law, the amendment bill that is introduced in Lok Sabha, even procedural coordination is not mandatory on a group. It is subject to the committee of creditors saying yes to that idea. The committee of creditors are the people or are the entities who say that yes, group insolvency will be beneficial for this group companies, and therefore we would want to start the coordination process through the process of law that we have. So it's not compulsorily imposed. Even in case there is a group, creditors may choose to say that no, group insolvency is not resulting into any synergy, and we would want to rather solve this in different pockets. Of course, then you were very clear in saying that this is only applicable to insolvent entities. What does that mean? That would mean that if A owns B and A is under insolvency and B is not having an NPA, not having a default, not insolvent under the terms of IBC, then there is no circumstance in which B can be consolidated in the insolvency process, or an insolvency process can start for B. I think that's also something that was very clear from your side. Group would involve control and ownership. Based on that, the group is being defined. So whether that's part of a group or not is something that you looked at. I think another aspect that I would want to add is that I believe the committee also talked about joint application and said that joint applications can be permitted. Joint applications, however, again, will not be compulsory. So in case a bank or a creditor wants to act against the entire group altogether, they can move separate applications, but they can be moved in any of the tribunals in which any of these companies are required to be having a jurisdiction. I think that is what is the idea there. Then a group strategy, you were very clear that what are the objectives of the coordination that is happening. One, there's a group coordinator. Group coordinator makes sure that the information flow is clear. Group coordinator makes sure that, yes, a group strategy can be prepared. And if I'm not wrong, they have recommended that creditors can choose to invoke group insolvency for a group with 50% voting, and they will approve the group strategy with 66% voting. In case the group strategy is not initiated or not passed by them, then this coordination committee can also be disbanded because the strategy is not getting formed. So I believe that is also, the termination is also something that the committee is proposing for. Interesting thing to add here is that when we look at chapter 5A, which is part of IBC amendment bill, and which talks about group insolvency, this is section 15(9)A that is being proposed in IBC. It's a section which is very different from other provisions or other chapters in the section, because other chapters talk a lot about how things will happen, whereas this chapter primarily talks about a framework, a broad framework, and provides that everything else can be provided in the rules. So that would mean that the government, I think, has thought about it, and maybe they understand that this process will evolve through jurisprudence, group insolvency, and its relationship with even cross-border insolvency. So that's perhaps the reason that they don't want to come back to the parliament to kind of make changes as law evolves or as jurisprudence evolves in this space. So anything that anyone would like to add in this framework, or how the committee is talking about this report, anything else that maybe I have not consolidated, maybe others can add, and then maybe we can move to the understanding how this is working out and how this has been taken care of in Australia from Professor Jason.
I think one thing I like to add is a little about the challenges in the implementation. As something, the recognition of the challenges were also recognized by the committee. I mean, the fact that building of institutional capacity was extremely important and is very important for us. It is one of the biggest challenge where where the lack of capacity at the NCLT level and CLAT level to actually handle a very complex, maybe group insolvency or maybe a very complex cross-border insolvency. So this is something which was recognized, and right now also it is thought of that specialized expertise is required, and capacity not only the NCLT level, even at the insolvency professional level, for us to be able to understand, is our private sector, how ready is it right now, whether it is the insolvency professionals or the creditors, even because the new group insolvency procedures, which we could thought about, it would require a lot of further training, a lot of capacity building. I mean, we in this last 8 years have built our capacities to a very large extent. We've been a part of a lot of awareness programs for all stakeholders. So this is something, again, further capacity building will have to be done so that it becomes successful. So having a law and making it successful and a very successful implementation of that is also something which is much required. So how also judicial readiness. So how our courts also may require specialized training, familiarization with the international cross-border insolvency principles is something also which is important, because COMI is a very important aspect. Cooperation between foreign courts is something which will also have to be, we may take time to implement. So yes, the law is being introduced and a lot of amendments are going to be coming in, but we need to be able to understand all of them, whether it is the reciprocity agreements are there. So whether the reciprocal recognition of a foreign insolvency order so is actually also contingent on India signing those bilateral treaties with other jurisdictions. So right now it may take a little time. Yes, the path forward is it's the insolvency regime is evolving very, very rapidly. I mean, we are actually serving as a model for the other emerging markets. I know a lot of countries look up to us to, because we are the ones who are making the jurisprudence in the insolvency framework, and we are ones who have taken the lead. But yes, and also I think we are moving towards eventual adoption of the Neutral model law. But we need to also understand the challenges and what all steps need to be taken so that it becomes successful on a larger scale. So this is just my 2 bits which I wanted to say in the end.
I think Pujaji, I totally second with you, because one of the cases which came to us in our firm, this was a set of 3 companies, all kind of not interlinked in terms of resolution, but belonging to the same group. And yes, these were consolidated into one to one NCLT bench with the hope that yes, they will all come on the same page. But what used to happen was that only the first matter used to be heard, and all other matters used to be posted for the next date. So this was the difficulty, and I believe that was purely a capacity issue, which we, of course, need to deal with. Um, I would now, of course, want something to be shared by Professor Jason. I understand that when I go through the CBRC report, it does mention what Australia has done with respect to group insolvency. And even otherwise, I think for all the delegates who are here with us, they would want to understand basics about how Australia has evolved its IBC laws. Since when is the law there in Australia? How has the jurisprudence evolved in Australia? And maybe we can learn something from that process. Over to you, Jason.
Wonderful. Thanks so much for inviting me. I'm delighted to be speaking at this event today. In India's evolution with the IBC has been of great interest to us here in Australia, and it's something I've followed very closely. And the issue of corporate groups and seeing how your adjudicating authorities are dealing with the corporate group problem in insolvency has been very interesting and something that is the focus of my research. So just before I take you through Australia's journey, just a little bit about myself. So I'm Professor of Corporate Law here at Sydney Law School in Sydney, Australia. Previously, I used to run a training program for people who wanted to become insolvency practitioners in partnership with the Insolvency Association here in Australia. And I've been researching mostly corporate insolvency, but also sometimes personal insolvency for the past 25 years. And I write papers and some books on those issues here in Australia. So to turn then to corporate group insolvency and to give a little bit of background on Australia's insolvency laws, our insolvency laws derive, of course, from English insolvency laws, and we have, liquidation, we have receivership, we also have a form of administration, which in some amusing ways, England ended up adopting some of our administration procedures, particularly the out-of-court initiation elements. It's very common in Australia where you have a large corporate group to have multiple forms of insolvency. So you might have some companies in the group that are in administration, some companies in the group that are in liquidation and or receivership, and also some companies in the group typically operating or license holding entities, which are actually deliberately kept outside of the formal insolvency procedure because we want to preserve the operational capacity of those businesses. And as many people on the call today will know, for many businesses that are based on licenses, if they go into insolvency, sometimes the licensor or the government can take the license away, and that erodes the value of the business. So it is very common for corporate group insolvency in Australia to have layers of different types of insolvency procedures some companies in insolvency, some companies not in insolvency. The development of our laws really over the last 20 years has been very interesting. I mean, we've had the administration procedure since the 1990s, and that at various times has been the second most popular type of insolvency proceeding. In Australia, at least for the last 20 years, a creditor's voluntary liquidation is the most common type of insolvency, and more recently, just in the last couple of years, we've introduced a debtor in possession regime for small business restructuring, which has become incredibly successful. We're getting thousands of cases every year now. So there has been quite a lot of change in Australia. I would say that our laws are trying to regulate both very large and complex insolvencies, but also smaller, what we call in Australia mum and dad company insolvencies as well. We do have very separate laws for corporate insolvency on the one hand and personal bankruptcy on the other, although there can be a little bit of overlap sometime. We do have a corporate regulator who's responsible for insolvency, but we don't have a government liquidator's office, for example, so it's all the private profession. And in Australia, you're talking about, in the most recent financial year, we had about 15,000 companies file for some type of corporate insolvency. We have about 720 liquidators in Australia and about 260 personal bankruptcy trustees in Australia. So that's a bit of an overview of the profession. Turning then to corporate group insolvency. So many of the issues that were raised in your various reports on corporate groups and the IBC over the last 5 years in terms of raising concerns about how some sort of consolidation regime might affect financing structures, how a consolidation regime might affect, for example, employee entitlements or certain trade supplies, and certainly how it might affect the banks. They were concerns that were raised in Australia. The issue of corporate group insolvency has been debated in Australia for at least the last 40 years. There were some proposals to create a consolidation regime, and they were typically rejected. Now, that changed in 2007. So for almost the last 20 years, we have had a formal substantive consolidation and procedural consolidation law, but only for groups of companies that are in liquidation. And that, I think that is one of the weaknesses of our regime, that it's not flexible enough to extend to companies that are also in administration or also in receivership, or indeed to include non-debtor companies that in fact are not insolvent at all, like operating subsidiaries. So that is one limitation. What that tends to mean is the formal consolidation regime, which we call pooling, tends to involve, I would say, small to mid-market companies, usually that have been in liquidation for some time. And there is a recognition that if the separate individual liquidations are to proceed, then that will result in a much worse outcome for all of the creditors. So what's very common in our corporate groups, even in, unfortunately, some very large companies, is a failure by the promoters of those companies to actually formally respect the separateness of the different companies in the group. So it's very common, as we've seen in some of the cases that you've had in India, to see assets being moved between entities, to see employees working for different companies within the group, sometimes to not maintain separate bank accounts, so there might be one consolidated account for the entire group. And often it's even unclear as to which company in the group owns the assets. So we've even had some large listed public companies where you wouldn't think that would happen, but actually they don't know which company in the group owns the asset. They just kind of assume the group owns it. And so while companies are trading and able to pay their debts, maybe that's not so big a problem. But when we get to insolvency, that's when we see all the problems appearing out of the shadows. And so with our pooling regime, or substantive consolidation and procedural consolidation, basically how that works is there's two options. So a liquidator can propose that a pooling be implemented within the group that is in liquidation. Now, it's very common in Australia where you have a corporate group for the same resolution professional to be appointed to different companies in the group. Where there are potential conflicts of interest, then we might have a different RP appointed, or perhaps what we call in Australia a special purpose liquidator appointed, who is appointed specifically to address particular independence concerns. But it's very common for the same firm to be appointed for all the companies in the group. And so typically they would then propose to each of the different companies' creditors that they believe a pooling is appropriate in these circumstances. And the way they tend to do that is to say, if we don't pool, then this is what the financial position is likely to be. And if we do implement a pooling, then it's going to be better off pretty much for all of the companies in the group. Now, creditors still have to vote on that. One big difference between the IBC and Australian insolvency is we do have a COC in Australia, but they actually don't have that much power. It's quite different to the IBC. So our COCs really are just there to advise the RP. It's actually all of the creditors. So to frame it in Indian phraseology, both the financial creditors and the operational creditors essentially have an equal vote in Australia in terms of going into a pooling. So the creditors would vote on the pooling. If they say no, then the liquidator can go off to the court and can seek a court order to implement the pooling. But importantly, if there are any unsecured creditors, so I guess what you'd call operational creditors, that are materially disadvantaged by the pooling and they do not approve of it, then the court is prohibited from implementing the pooling. Now, how insolvency practitioners deal with that here in Australia is they will use the pooling powers to basically carve out groups of creditors that they think are going to be a problem. So a little bit like with a creditors scheme of arrangement, where you can kind of pick which classes of creditors you're going to include, it is possible to do that in a pooling. So we have had some cases where there's been a big group of companies. In this case, it was an airline, not quite as bad as Kingfisher, but one of our larger corporate collapses here. And we had one of those companies that had a very valuable asset, but the creditors of that company were complaining and it was going to bring down the pooling. And so the insolvency practitioners just excluded that company from the pool. So we do have a steady stream of cases in Australia. There's probably been about 30 cases over the last 20 years, and we're seeing more and more cases each year. I think the Revenue Authority and also the Department of Employment are becoming slightly more comfortable with the idea of pooling, particularly where it is going to result in a significant benefit to creditors. And how that happens in Australia is the intra-group debts and claims are cancelled out. So in many of these groups, there are significant claims, using assets or paying for employees. And if they're going to be cancelled out, often that will result in a significant increase in the cents per dollar that creditors receive. So basically that's pooling in Australia. Looking at the draft of the bill that's been released for India, it's interesting some of the differences. So we have a broader definition of a group. So it can be, for example, where there are joint debts. It can be where they're running a joint business. And of course, it can be where there is some sort of formal control, like a parent subsidiary company or broader related party relationship. So that's one difference from the proposed provisions in India. We also have a procedure in Australia called a contribution order. Now, this is very broad, but in fact has never been used in the courts yet. It's only been around for about 5 years. And that allows the court to basically deem a group of entities, not just companies, but also trusts and partnerships, for example, if they're operating as a group, and it involves the underpayment of employee claims. So the court can make a contribution order, and that can even be against a company which is not part of a formal insolvency. So that's a very broad provision, and both New Zealand and Ireland have similar laws dealing with third-party contribution rights. Of course, in the US, it's also slightly different. So once a company goes into a pooling, either through a liquidator's determination approved by creditors or through a court order, then under the Corporations Act, which is our main corporate insolvency legislation, they're treated as a pooled group, which means you can have a consolidated creditors meeting, you can have one report to creditors instead of multiple reports, you can have one approval of remuneration for the RPs who are in charge rather than doing separate applications to approve remuneration. And basically the procedural aspects of the insolvency are much easier because it recognises this idea of a consolidated group. So yeah, it's been used for both small groups of companies, but also some of our largest insolvencies have also used this procedure. So it's very flexible. And talking to insolvency practitioners, I think it is largely well regarded. Now, it could be improved by extending to non-liquidation types of insolvencies, It could be improved by providing a little bit more flexibility where there are dissenting creditors, although it's interesting that earlier you talked about the developing jurisprudence in India and how that interfaces with the draft legislation. And we've also seen that in Australia in terms of the limitation on no material prejudice. Well, the courts have said in liquidations where the returns to creditors are very small, that will be a relevant consideration in assessing material prejudice. So if a creditor was only going to receive 1 cent in the dollar return, then how much prejudice are they really going to suffer? So yeah, overall, I would say it's been largely successful in Australia, although I think it could be expanded. It could be a little bit more flexible.
So a follow-on question here for you, Jason. When we talk about, you say that liquidation, yes, there is a possibility of this kind of a coordination. I hope you're here.
Yep.
Yeah.
Yes.
So with group consolidation, you said it's mostly prevalent in liquidation, and some kind of a coordination happens automatically when a group, when 2 or 3 group companies are in insolvency in Australia, automatically because of how the creditors conduct themselves or how the insolvency professionals are leading that insolvency process conduct themselves. Does it happen automatically as well, even if it is not having an official coordinator like India is proposing right now?
It basically does. It's a really good question. So the law technically requires each of the insolvencies to be conducted separately. So if you're a liquidator who's appointed over, say, a group of 20 companies, that they are 20 separate liquidations, and you will need to do 20 remuneration approvals, 20 reports to creditors, although in practice you do combine those. How they're able to get around that is we have some provisions in our Act that both allow for an application for directions from the court. So we don't have specialist insolvency tribunals like you have in India with the NCLTs, but we do have some of our state and federal courts that tend to do more insolvency cases. So they kind of are specialist insolvency courts, but they're framed as being just general Supreme Courts and federal courts. So you can go off to the court and say, look, I'm supposed to have 20 separate meetings, but there's only $1 million in assets. This is a deeply insolvent company. If I hold 20 separate meetings, it's going to cost me $500,000 because there's 10,000 creditors, and that's going to be worse off for everyone. And so the court generally will say, oh, that's okay. You can just hold one meeting. We'll basically wave that through. We also have a provision in our companies legislation, the Corporations Act, that says if you fail to comply with a procedural requirement in the Act and it causes no substantial injustice, then generally speaking, that's okay. It's that the Act is not invalidated. So what many insolvency practitioners tell me is, if they go off to court and get permission, that's still going to cost them some money. And so they will, write to the creditors, keep them informed and say, look, this is what we're proposing to do. If anyone has an objection, you can write to us, but we're just going to hold one meeting and invite everyone to the same meeting. Of course, as long as the records of the company are accurate enough, you should be able to work out which creditors are creditors of which particular company. But that indeed is the problem we found in some of these cases, is the company just doesn't have books and records. And so the creditors believe, oh, well, I'm dealing just with the brand of the company. I don't know if it's this company or that company. And so in many of those cases, you're really relying on the discretion of the chair of the meeting to say, okay, we're going to allow these people to contribute and we'll just, note their claims. And if we get to the point where either the vote is contested or the dividend, if there is a dividend, is contested, then we can actually work out which company they are creditors of. So yes, there are both procedural ways in terms of court powers and also some saving provisions in our Corporations Act that facilitate that.
Thank you so much for sharing that thought. So I will be sharing some examples where we have in India also, looked at some kind of a coordination or cooperation between different processes so that the value creation can happen for creditors. So in one of the cases where insolvency was in process for a company, the company only had ownership of the building, whereas the land was still owned by the promoters of that company. In that process, what we did was we did work with the creditors, and since the creditors had the entitlement to act under SARFAESI, for SARFAESI is of course a law in India where we kind of take over, the banks can take over mortgaged assets and then auction them in the market. So we did merge the two processes, because auctioning the building separately and auctioning the land separately would not have given or generated value maximization for the creditor there. So we did merge those processes and try to kind of do a joint auction. In another of these processes where one company was in insolvency and its subsidiary was also under insolvency, there was a lot of information exchange that happened to the limit, to the extent that it could have resulted into value maximization for both the processes. Although these were distinct businesses, the companies were not having too many interlinkages, but yes, creditors were common and there were some interlinkages with respect to how the management and how the employees were working for both the companies together. So some kind of partnership or some kind of agreement was there between the insolvency professionals, that if the holding company had certain people who were also working for the subsidiary company, then they can continue to give that or devote that time for the subsidiary company's processes and operations while both the companies are under insolvency, rather than creating a hard line that the holding company is paying for those salaries and therefore the subsidiary company will not get the benefit of their time.
Yeah.
So some of these things I believe we continue to have in the process. Any of the panelists who would want to add anything to what we have discussed so far and what maybe Jason has shared with respect to Australian process, once we have had everyone's point of view, then maybe we can move to some questions from the delegates.
Just adding here, and I think the reason why India has overall chosen the whole procedural coordination part rather than substantial coordination part is because substantial coordination has much more complexities altogether. Because there will be the whole idea of having cross security, or each lender having a different kind of security, and which resulting in more litigation. And litigation, unfortunately, is the biggest bane which comes forth in India altogether, and the delay which that causes. And so therefore, that's the reason I think we've kept ourselves slightly distant from the substantial consolidation as on date, and ensured only procedural coordination. And secondly, also the fact that because of the fact that our insolvency regime is so time bound effectively, or at least the focus is for it to be completed within a specific period of time. If we go ahead with substantial consolidation, that time period gets completely thrown out of the window. So I think these are the two primary reasons why we've kept ourselves away from that bit. Though I think in the future that is something which is definitely which we should be exploring as well, because we have seen that there are companies wherein as Professor Harris had just highlighted, that one very substantial asset is kept in a particular company, whereas the primary business is of the company which is, say, for example, listed, or which is the holding company altogether. So those are issues which we will face, but let's see how this develops in the future.
Thanks for sharing that, Siddhant. And I think I forgot mentioning that the report also suggests about 90 days, which can be provided extra over and above the existing timelines in case group insolvency is initiated, so that these 90 days can be used by the committee members to facilitate and prepare this group strategy and pass that or approve that. That's also something that I believe the committee had thought of, that additional time will be required wherever such kind of a coordination is required between the committee of creditors.
Correct. Just one more point, Ankit. In fact, while we had discussed that primarily the legislature, what today it provides is an indicative principles effectively on which group insolvency will be based, while the specifics will be provided by the regulator altogether by virtue of rules or regulations. But at the end of the day, also there will still be legislative oversight over this, because every rule which is drafted under this particular section has to be placed before the parliament, and that's how the draft bill has been brought about. So while legislature has tried to delegate it to the regulator, but at the same time ensured that we have a proper oversight.
Yes, I believe we have so many laws which are now being framed in India, which provide for flexibility for the government to make changes, because the government understands that the time that the parliament has is very limited, and also it becomes difficult to get something done in the parliament with other priorities in place. So I think that's the idea. And when the rules are framed, they are of course tabled in the parliament. But because they don't need a specific approval, I think that is easier than getting a law passed.
Definitely. But it ensures oversight also so that the legislature has a view of what is happening.
Perfectly right. So I believe we can take some questions from our delegates. We can understand if they would want to ask something from any of the panelists. We have about 20 minutes to take various questions.
Sir, am I audible?
Yes, sir, sure.
Yes, sir. So I had one question. Let us assume that in our country, there's one company, there's a group of companies, and the main company is in India. The parent company is in India. It has the center of main interest in India. And in a situation where assets are in multiple countries, but all of these multiple countries have separate laws for charge on properties. Let's say they have different charges on different type of assets in their country, then how can a professional sitting in India, how can they coordinate and they can assure that the properties are, secured in India and the asset pool is created?
Anyone who would want to answer this?
So maybe I'll just give a few words, and if
Yes.
anyone wants to add there. See, Harsh, right now, unfortunately, our law is not envisaging this. Our law is entirely focused on domestic companies vis-a-vis group insolvency. Right? We have seen one instance in Jet Airways whereby, on account of the application of the resolution professional in India, there was a request made to the courts in the Netherlands vis-a-vis coordination. But that was only in the nature of a request today. So unfortunately, we do not have a framework in place altogether for cross-border. Yes, there have been certain changes within our law to bring about something by virtue of rules and regulations. And at a future point of time, there have been enabling provisions which have been introduced, but how and what would be the overall structure of those provisions and how they will function, because technically speaking, India does not have any kind of bilateral treaties as of now to recognize each insolvency proceedings. So what will be the mechanics of it and how it will get recognized is something which we'll have to wait and watch.
Right. Understood.
I think to add to that, yes, Jet Airways is a very interesting judgment, and I think I understand that there's a lot of applause that is there for the maturity of the NCLT in India, that they were able to envisage that how to practically handle that issue. So there, I understand that issue very simple, that there were certain aircrafts which were leased by agencies in Netherlands, and some assets were also there in Netherlands, and some of those assets were here in India. And the courts showed maturity by saying that yes, we will respect to the limit to understand or respect the charges that were there on those aircrafts by those agencies or by those companies in Netherlands, and recognize them accordingly in the process. And they, I think, also accepted the UNCITRAL framework to a limited extent so that this kind of a cooperation can happen. The alternative would have been to have a thought process that no, everything that belongs to this company belongs to the creditors who are in India, and we will not respect the creditors outside India at all. But I believe in any such circumstances where the assets are outside India or the assets are in India and the creditors are also belonging to an outside country, that maturity needs to come in for India to rise as a place where businesses or foreign companies or foreign entities can trust and invest money. Even if you see how the Go Air episode turned out, I think everyone would maybe understand or know about it already, that when this insolvency started, almost all the aircraft that this airline had were all leased. And the idea there was that since the law did not recognize the lease as a secured financial debt, the idea behind initiating insolvency was that this is the value that will be created from the insolvency process or resolution plan, and that value will go to the creditors. And since there was a large protest, and there was also the leasing companies understanding that this risk is there in the Indian market, increased the lease rentals for all the other jets that were supposed to be used in India. And there was a genuine difficulty that that cost will be passed on or will be required to be passed on to the end consumer. there was a change in law. The notification was made that this will not be a recognized debt for the purpose of insolvency in India. So you kind of see such changes and such interferences by the government whenever you feel that yes, something is going to the wrong direction, which is not overall in the interest of the creditors put together.
Yeah.
So I believe, Harsh, that should answer your question. I think
I just had a
time and
small
again,
point to
whenever
add, Anit, to what Harsh was saying. So, because the cross-border insolvency model law, which is there, it's not like a treaty. So even though India does not have formally have adopted like any model or any procedure, Indian proceedings are already getting recognition in international jurisdictions. So if there are jurisdictions which are actually having model law, like Singapore, to my understanding, recently has given recognition to CRP. So definitely, if there can be a relief that is required, we can go to a country which is having a framework and, like, to answer your question, may get a relief over there. Thanks.
And
Understood.
I have witnessed some events where Indian company owns a subsidiary in Singapore, owns a subsidiary in an African country, and has some assets there. And I believe that wherever the issue with respect to further encumbrances in those countries do not arise, we do see corporation and the insolvency professionals managing to inspect those assets, managing to create value out of sale of those assets for the creditors in India.
Ankit, can I make
Mr.
one
Batra,
point here?
yeah, I was in fact hoping Mr. Batra was someone who was involved in the recognition process in Singapore, so he might be able to.
Well, thank you so much.
Please.
And I've been listening very much to all the discussion, and thank you so much for all your comments, and a big hello to Jason as well out there. I know it's very late for you, but thank you so much for joining. I think to me, the importance of the Jet Airways is not for the reason that the court found a solution which facilitated the disposal of the aircraft that was parked in Schiphol Airport. I think that was the outcome of what the appellate tribunal did. But before I mention that, I also wanted to tell you that it is the foresight of the appellate tribunal NCLT did not appreciate. NCLT, in fact, rejected our application because I filed the application on behalf of the administrator, who was in charge of the Dutch proceedings. Because the NCLT said, one, there is no cross-border insolvency law in India, so I don't recognize the Dutch proceedings. Two, it said that if at all, we can recognize this under the Code of Civil Procedure, where you have to file a proceeding for a recognition of a foreign order. And if you have satisfied the test, then of course it can be enforced in India. He said that has also not been done. Well, fair enough. I mean, he had what he had in his mind. But I think what irritated the appellate tribunal was the observation in the NCLT order that I direct the Indian insolvency professional to disregard the proceedings in Netherlands. Now, when we filed an appeal, and fortunately, Justice Mukhopadhyay had just returned from Singapore after attending a judicial colloquium on cross-border insolvency. So he was very fresh in his mind on his understanding of the importance of the cross-border insolvency and how it works. So he said that how would the Indian insolvency professional have a closure of the proceeding here unless you also have a closure of the proceeding in Netherlands? Because even if you have a resolution plan here, but no closure in Netherlands, any plane that lands in Schiphol, they would attach it in order to recover their dues if you don't pay the dues. And there was, in the meantime, attempt to start proceeding in Paris as well. So Justice Mukhopadhyay recognized he had the foresight to recognize that a resolution will not really be possible without a problem unless you bring both the parties together. And he asked very simply to the councils who were present for COC and IP, and of course, I was there for the Dutch administrator. What is it that you think that the court can do to help? And then I suggested that you ask these parties to sit together, the Indian IP and the Dutch administrator, and work out a kind of a cooperation agreement, kind of a protocol. And it is the maturity of the advisors of the COC, of Jet Airways, of the lawyers who were advising the Indian insolvency profession, and of course the other players who made it happen. Within a short period of about 2 to 3 months, they thrashed out a protocol that was a mirror image of the cross-border, UNCTAD cross-border protocol, with the Dutch administrator ceding that the main proceeding will be in India, and that's how it should be. The only condition that we insisted on was that the Dutch administrator should be invited as an observer on the COC meetings in India, but without a voting right, which the Indian lenders did not agree. And I think they were rightly advised by their lawyers, because there is no such provision in the code for someone like that to be invited as an observer. But we were able to persuade the NCLAD that there is no bar also. And in a given case, you can invite anybody who you want as an observer in order to facilitate the process. And Justice Mukhopadhyay then directed that by an order that the judge administrator will be able to attend the Committee of Creditors meeting, but of course not observe. The rest, they say, is history. So I wanted to tell you that it was his foresight of the fact that you need this cooperation to make the resolution happen in Jet Airways. That was what weighed in his mind, and that I think is a great amount of sign of maturity, and that is why it is talked about as one of the classic examples of the maturity that Indian judiciary has shown. Thank you.
Thank you so much for correcting that, Sumanji. And yes, the credit does go to
So
NCLAD.
I didn't want to correct. I didn't want to correct. I just wanted to throw light on this.
I think and the insight that you have in this matter is, of course, it was wonderful to hear that and understand that how this kind of evolved. And I believe all the jurisprudence today is what we can credit this evolution in the law itself. And I was seeing that Chapter 5A, in case you look at one of the clauses there, it does talk about a cooperation agreement or an agreement between the creditors that can facilitate the entire process, which is now also part of the draft, the bill as presented in the Lok Sabha. So I believe that's also something that is coming from that jurisprudence in some way or the other. So maybe we can have other questions, if any.
Good afternoon, everyone. Am I audible?
Much.
I have a question, sir. From a creditor's perspective, a group on insolvency may dilute individual recovery prospects. So, how can law safeguards the creditors while still ensuring efficiency for the resolution?
So the key there, Vanshika, is that one, there is no automatic merger of all the assets and liabilities, I believe. So that's something that we pointed out. And therefore, if the resolution plans are being approved at the individual COC level, each of those COC members will probably take care of their interest. And in case they have a security which is much higher as compared to the kind of plan value that they're getting to themselves, they will choose to dissent, and then of course we follow then the waterfall mechanism and how they will get at least what they deserve through the security mechanism. I believe others can also add, I believe the cooperation agreement and the group strategy is also binding on all the creditors. So when the group strategy is being formed, I think logic will take all the creditors to a space where they will respect these security values and the preservation of their interests in whenever they are proposing this group strategy, with that keeping in mind that how the entity will be able to continue and how the enterprise will be able to continue undisturbed after the resolution plan is passed.
Yeah, I'll just add one point to what Vanshika was saying. So as we were discussing right now, because mostly what CBRC report actually envisaged was a procedural coordination. And interestingly, they never ventured, and they said that the fact that what will be the positioning on approval of a plan, which will actually have a manner of distribution, that is not something that can be delegated to a group COC. That ultimately will reside with the main COC. So the creditors will ultimately take care of an interest, because what you are saying is a very important question that comes on substantive consolidation. And that's why, as others can also like pitch in. So in US, when they are recognizing this concept, to my understanding, certain courts have also looked on the factor that the benefit of substantive consolidation should actually outweigh the harm. So ultimately, that becomes an harm. Ultimately, becomes a harm also of the aspect that who will be the people who will be losing out, because there might be a certain entity who might have all the main primary asset actually lying there, and their creditors will be at, like someone who will be at the losing front. That's why when we talk about procedural coordination under the CBIRC report, those creditors will definitely agree only when they have a better value that can be derived. So that may be taken care in terms of the negotiation that will go on in the creditors, between the creditors.
Thank you, Akash, for adding that.
I
So
just
Nikhil,
wanted to add one
yes, sir.
comment here. Not exactly, a response to what Vanchika you mentioned, but Akash, just to supplement what you mentioned, that at the committee, of course, the committee report, happened 2-3 years ago, and I was listening to the Videocon example that you gave. So even much before Videocon, for that matter, when Amtech, Videocon, and some of the other companies that, in fact, as a part of the first 12 companies that were posted in insolvency, many of them were actually group companies. Some of them, as a group company, went into insolvency in the second round when the second notification of RBI came. And when the second notification came, I wrote a letter to Dr. Sahu with copy to the then Secretary, Minister of Corporate Affairs, Dr. Injeti Srinivasan, that this is going to be a major problem for you in terms of being able to optimize the value of the assets, because this fragmented approach will not work. And that's why at some point at that point in time, Dr. Sahu was persuaded to set up a working group, and Shardul was also part of that. Behram was also part of that, and I think Shardul made excellent contributions in that, in order to inform the committee in terms of why substantive consolidation is going to be a big legal challenge in India, based on the sovereign principles that are well regarded, and that is why the committee recommended that let's just not go into that territory at all. I had presented a paper to the committee at that point of time on saying that we should create one exception of a fraud, although that exists in the Indian jurisprudence any which ways. And Edcom also was in the highlight by that time, and we knew that the piercing the veil principle, extending it to the trust, how would that work? So we debated a lot, that can we include trust as a part of the group entity if essentially, all the assets are parked in a trust. But again, we felt that it's a big legal challenge. And of course, in the meantime, the institutional developments happened, and that's why the whole issue got delayed a little bit. But the challenge that I see going forward is Section 29A in terms of the group insolvency. So, for example, 6 subsidiaries of a of a holding company, 4 an insolvency, 2 are good. And the holding company believes that it can actually put in a plan and take the 6 subsidiary companies out of it, have a plan of, merging those into the holding company or into the other 2 subsidiary companies. But 29A problem will apply. And therefore, even though you have a procedural consolidation, but you're not facilitating, not just substantive consolidation, I'm not on that, but a real-time resolution. So we need to carve out exceptions for these kind of problems to really make resolution of group companies happen in a way that you're able to maximize the value. So procedural will definitely help, but there are other obstructions that we need to deal with going forward. But I'm hoping that in due time we'll come over these kind of challenges as well.
No, well said, Sumanji. And I believe there, of course, for those group entities which miss the bus in reorganizing their affairs when their debt is high or they're in the state of insolvency, and if they're not able to manage the position or manage the possibility of diverting or shifting funds from a surplus entity to a deficit entity before the insolvency proceedings start, there again, this 29A difficulty will come. Of course, we always have seen examples where holding companies have come under insolvency because of some default, but they have some subsidiary companies which are still doing well, they don't have any default.
Yeah.
And in those cases, we do find that when we go for a resolution plan, we find value in the form of the value of the shares that the holding company owns. And of course, with shares comes some kind of eventual control that passes on to the new management that the resolution plan takes forward. So
But
that
flip side of that also is at the same point of time, because if now we have the pre-insolvency resolution introduced in this bill as well, creditor initiative, and since the 29A disqualification typically would trigger in 1 year after the NPA classification or the default or the classification, whatever. Hopefully, the group companies and even the companies would be incentivized to approach the creditors and start the pre-insolvency process before the disqualification triggers in. And that, in my view, also therefore will work as an incentive and a disincentive both. So it's a good balance in that ways. It's just that we need to build these kind of narratives. You need to inform the stakeholders that this is how you can take benefit of the law and overcome also 29A and let it not become an abuse. And hopefully this narrative would start happening soon.
Right, and definitely, sir, the creditor initiated process which has been introduced now will be a big step towards it, because it's a complete departure from it's a debtor in control concept with some veto powers with the RP. So that will be a complete different change and will give the promoter some boost to do an early resolution of the whole company.
Yes,
Keep
yes,
control
Siddhant.
rather than lose control by virtue of CIRP.
And I think, Siddhant, firms like yours have a big role here because you work so much with the big lenders and also with the corporate houses on the finance side and others. So to be able to bring this narrative closer to their heart, I think this is very important. I think we should discuss this as well at some point in time, how you can start holding workshop with these people to inform them the real purpose of pre-insolvency resolution, so that we can make a full impact of that.
Definitely, sir, because it's quite a useful thing. It gives you a court approval rather than the informal process which RBI had earlier by virtue of the 7th June circular. So it has many advantages which we can discuss later, maybe not today. But
yeah, of course.
Definitely.
So we can have another question, I believe, before we wind up, if there is any.
Excuse me.
Yes, please.
Hi everyone. My name is Avni, and firstly, thank you for all the insights on group insolvency. So I have a question in furtherance to the creditors and the dissenting shareholders' rights itself. So I understand that this could be a very far-fetched question at this juncture and a very practical question, but in group insolvencies, in group companies often have intricate financial relationships, including cross shareholdings, intercompany loans, and joint guarantees as such. So there could be a situation when these relationships are unwound through substantive consolidation. During such cases, minority shareholders may discover that their company's assets were effectively pledged to support the other company's entities' obligations through complex guarantee structures. So these kind of interlacing of finance is common in group corporates. This stakeholders with lesser bargaining power in such situation are often at a disadvantage. So I would just like to know your opinion on, do we have the laws or regulations, or what kind of regulation should we come up with to guide these kind of finance agreements, before even we look at insolvency of such companies?
So maybe I can quickly say, Avni, that when we talk about any structures of financing that are implemented by creditors, they would typically go ahead with a mortgage or with a collateral in place, and they can of course go for added guarantees or added corporate guarantees and so on. So any creditor who is part of a process, if they feel that yes, their security is highly deficient in terms of their exposure to a company, that creditor would be open to pooling in the various resources or looking at surpluses in other companies. At the same time, there will be some creditors who will have surplus security with them, and they will always be open to sharing that security value, excess security value with other creditors, provided their interest is taken care of. So in case there is a simple agreement between the different committee of creditors, maybe two or more corporate debtors, which simply says that when they are approving when they're preparing a group strategy with respect to resolving the entire issue with respect to insolvency, they will preserve the value which is available to the creditors, which is based on the security that they have in any of the companies, which is the first layer of security. And of course, the surplus is something that will be maybe distributed in an X point of manner. So this is what I envisage will happen, and this is what commercial wisdom of any creditor will allow them to accept. We do have case laws, we do have interpretations of the law in place in the jurisprudence, current jurisprudence, where the minority creditor in a COC has not been able to get the rights or get that value which they would have been able to under Section 53 in case their security would have been, if in case they would have been able to liquidate the security outside the IBC process. However, I believe that the amendment bill which is presented in Lok Sabha also has the solutions to that problem. Others can also add if they want to add something to answer Avni's question.
Nothing from my end.
So, in case there are no more questions, with these concluding comments, I would like to officially close this eminent panel. The Insolvency and Bankruptcy Law Division, under the aegis of Center of Business Laws and Taxation, under the able guidance of Dr. Manoj, we extend our heartfelt gratitude to all of those who are present here: Siddhant sir, Pooja ma'am, Akash sir, Professor Harris, and Mr. Batra, of course, to curate this wonderful and informative session. I have personally learned so much in these 1.5 hours, and I hope for everyone who's attending that there is some substantial learning experience from this eminent panel. I especially thank Professor Harris for taking out time on a Saturday evening to guide us about the Australian practices and what India can adopt in order to make their very new and initial regime of group insolvency better and strengthening it. I also extend my gratitude to Mr. Ankit Goyal for moderating this session and ensuring that we can make the most out of it and all the attendees are able to absorb as much as possible. Apart from that, I extend my gratitude to Pooja ma'am. She committed to this conference 6 months back and she was always ready to come here. But ma'am, we hope to host you someday else, hopefully on offline. The panelists' guidance on some of the most important topics, such as procedural consolidation, substantial consolidation, single economic entity, and separate legal entity, and cases such as Videocon. And of course, having a great discourse on the new IBC amendment. We got the we have got the pleasure of hearing from Mr. Johri and Mr. Batra, who are directly or indirectly part of the suggestions which were made to the amendment or are pivotal to these amendments. With this, I would like to formally close the panel and thank all the esteemed panelists to be here. And I look forward to further collaborations, hopefully offline. And I request the authors and co-authors to leave the meeting, have the lunch, and join for your sessions as for the presentation rounds.
Thank you everyone for joining. On behalf of the university, let me thank everyone, especially the panelists, and for such a mesmerizing panel discussion. And I think this will go a long way in expanding the understanding of the students so far as insolvency and bankruptcy, especially the group insolvency is concerned. And thank you so much, every one of you. You have spared such a long time in discussing these things. And Professor Harris on a Saturday evening, thank you so much. And let me assure you that we would love to have you on campus as soon as possible. As soon as the weather permits, we would love to see you all here. So in some other program. Thank you once again. Thank you so much.
Thanks very much.
Thank you so much.
Thank you, everyone.
Thank you so
Thank
much.
you, everyone. Thank you,
Thank you so
Manoj.
much.
Thank
Thank you.
you. Thank you, fellow panelists.
Thank you.
Dubay sinjaman gedrak toka. Tapi sinjaman gedrak koru. Amat. Sinjaman gedrak.
So all the attendees can leave the session now, and we will reactivate the link at 1:45. So you guys can join around 1:55, and then we'll send to your respective breakout rooms for the session. So everyone can leave, and thank you so much for joining the session. Thank you.